Family law matters can be both confusing and frightening. And with all these different questions, it's very difficult to find the source for answers. Well, here's one for you. You can ask Andrew. Ask Andrew is the only online-based call-in show where Andrew Feldstein of the Feldstein Family Law Group makes himself available to answer all of your family law questions. So tune in and ask Andrew. Family law matters can be both confusing and frightening. And with all these different questions, it's very difficult to find the source for answers. Well, here's one for you. You can ask Andrew. Ask Andrew is the only online-based call-in show where Andrew Feldstein of the Feldstein Family Law Group makes himself...
seconds now, and then when I know we are ready to be received everywhere, we'll officially start. Hello, I'm Andrew Feldstein, the founder of Feldstein Family Law Group and the host of Ask Andrew. Ask Andrew is an internet-based live question and answer show about divorce. I'm in my office at our headquarters in Markham, just north of Toronto. We have other offices in Mississauga, Vaughan, Oakville, and the Bloor West Village neighborhood in Toronto. This show will focus on divorce law in the province of Ontario, but most will also apply across Canada with some differences in Quebec. No matter where you are in Canada, please feel free to call. As I speak to you, we are live on the internet on Thursday evening, June 16th, 2016. If you are watching on another day, it's because the show is recorded. You may be watching this show on youtube.com after putting Feldstein Family Law into the search bar. Or you may be watching it on the main Feldstein website, www.separation.ca. YouTube and separation.ca have all our earlier Ask Andrew shows, plus many video blogs produced by our firm's lawyers explaining many aspects of family law in the province of Ontario. We're excited that tonight we have a new way of broadcasting our show. Some of our audience are watching us on Facebook Live. The program on Facebook Live has the ability for people to post comments that are seen on screen by all the other Facebook Live viewers and are saved in Facebook's public files. More about this in a minute. There are 3 ways to ask a question tonight. Phone us at 1-800-498-3486. You can see the number right there. One of our staff will answer your call, find out what your question is, and put your call in line to be taken by me. You can send a text message. The number for sending a text is 416-303-8307, or you can send an email directly to me on my laptop here at andrew@feldsteinfamilylaw.com, which is also there. Please make sure your questions do not identify you. We want to make sure both your safety and privacy are protected. Again, this show is recorded so people can watch it later. The same applies to any comments posted on Facebook Live. But if you are showing your name on Facebook Live, remember that people will be able to see it and there'll be no confidentiality to your question. So please keep that in mind, and please remember any questions that you send in does not form any type of solicitor-client relationship between our firm and you. An hour goes very quickly on Ask Andrew. If we do not get your question, if we don't get to your question, our 3 websites might have the answer for you. Separation.ca, the one I mentioned earlier, is our main website. It describes how we work with clients, and it has easy to find information on all aspects of divorce. This is the largest website on separation and divorce in Canada, and all the information on it is free. FamilyLawHelp.ca explains everything you need to know to help you decide what aspects of your family law problem you can work on yourself, and when you really should get help from a lawyer. This concept is called unbundling. Our third site is itstimeforjustice.ca, and it has 2 white papers I've written explaining to Canadians in general and politicians and journalists in particular ways to make the family law justice system operate more quickly and less expensively. And in the next few weeks, we will add a white paper explaining the real-world aspects of self-represented litigants in family law court. Self-represented litigants is the legal term for people who go to court without a lawyer. And Feldstein Family Law Group has a free of charge initial half-hour consultation. Lastly, I really do know what you're going through. I underwent divorce myself only 3 years ago. So I understand your emotions, your stress, your anxiety, and your concern for your children. I learned it the hard way when I went through it myself, and I'm a professional in the industry, and I understood what the stress and anxiety was like for me. And I assume it's probably a lot more for other people who do not work in the industry. So I'm hoping to give back by answering questions on the show and having our additional website, FamilyLawHelp.ca. So please, in the next hour, send us your messages via text, email, phone them in, contact us on Facebook Live, and I'm hopeful that I'll be able to help you. And some people who are very eager want to get to the front of the line, and what those people do is they send me their script in advance, or not their script, but their questions in advance, and I have quite a number of questions here. Some of them are lengthy, but I'm going to try and start off with some of them that are lengthy and complex. So the first one came in from Dan. And Dan says, "Hi Andrew, we are working with a mediator to try and avoid legal costs and have completed financial disclosure and are waiting for the mediator to put together the net family property report and determine equalization. I'm a teacher of over 20 years and have a huge family law value of my defined benefit pension. I just found out through a lawyer at your firm that all locked-in assets need to be adjusted for income tax. Good news for me." Now, Dan, I want to start, before we even get to your question, to say that's some of the time. And the way equalization works is we typically would start by putting your pension into the calculation for equalization of net family property. And yes, we do have to figure out a notional discount for tax. The logic of that is when you have an asset like a pension, when it actually gets paid to you, you have to pay taxes on it. So there's going to be a discount. And that discount takes into account the fact that the investment's growing before you access it. And it takes into account that you're not going to pay the taxes for a number of years. And most likely when you are retired, your income is going to be lower than it currently is and will have a lower tax rate. That being said, in a number of cases, we now have the option to roll over half of your family law value of your pension to your other spouse, right at source. And if that's done, there'll be no notional discount for tax, because when your spouse accesses the money in their pension plan, they're going to also have to pay taxes, so it gets taken care of that way. So I'm continuing on with Dan's question, and Dan continues with, "My question is that your colleague mentioned that the legal industry standard for the tax rate is between 20 and 25%. How was this number determined? Should we be using the same rate if my retirement income puts me in a higher tax bracket?" Well, I'm going to start with the first piece. How is this number determined? Well, there's rules of thumbs in the family law practice that we frequently see used. 20 to 25% is the range we frequently see used, and there's not rocket science or a way that we calculate that. Dan says, "Should we use the same rate if my retirement income puts me into a higher tax bracket?" Theoretically, yes, you should, but frequently when you have a negotiation, both sides will negotiate for the same rate. Next question is, should I have an actuary work this out? Well, an actuary or a chartered accountant can be hired to find you or provide you with the notional tax rate. When they do the calculation, they're going to come up with an exact percentage that will take into account your retirement age. It will take into account your income on retirement, look at all the assets you have on retirement, and they will come up with an exact rate, and it will be different for both spouses if they're retained to do that. So that's the best way, that's the gold standard of it, but people frequently don't want to pay for that expert. And especially if you're rolling over the pension or half your family law value to your former spouse, it's a moot point. Next part of this person's question is, what do I do if I think the mediator, who is an accountant tax specialist, doesn't apply the rate or uses a much lower rate than this would drastically affect my pension adjustment? Well, if the mediator is an accountant, that suggests to me that they're using what would be a more exact number than I would be using. That means that they would be using the correct number, and you're probably going to be stuck with where you're at. You're not going to be able to do anything to change that number other than going and getting your own expert. You could say to the mediator that you've spoken to some lawyers and they tell you most of the time they take a rate of 20 to 25%, but you may very well be stuck. Okay, the next question that I received is a question from Mary. And Mary says, thank you, Andrew, for the opportunity to present you with some questions concerning separation and divorce. And she has a few questions and wants to give background information. So there's a fair bit of background information, and I'm going to read it now. I'll try and read it slowly so people can understand the background facts as well as the questions that are going to come up. And she says, her and her husband wed in August 1971. Neither of us had any assets at that time. I had no debt. My husband had student loans which we paid off over several years, and they have no children. My husband decided to leave the marriage in March 2006. Over the ensuing years, I've been trying to get him to settle, and he is reluctant to do so. I have had the service of 2 lawyers over the course of this time. Neither of us have the desire to go to court if possible. I really want to get things finalized between us, and I need to know how much money I will have left on which to live. Now, Mary hasn't got to the question yet, but I have to stop because certain things as a lawyer jump off the page at you and ring alarm bells. And in this particular situation, what causes me to see an alarm bell is she says she separated in March 2006. And here's the problem with March 2006. There's something called a limitation date. A limitation date is a law, and this is in the Family Law Act that says if you want to make your claim for an equalization of net family property, you need to do it within a certain period of time. And the Family Law Act says that you need to make your claim for an equalization payment within one of 3 dates. The first date is 6 years from the date of separation. So in Mary's situation, that'd be March 2012. The second date would be 2 years from a divorce. She hasn't said they're divorced, so that hasn't happened yet. And the third date would be 6 months from when one of them died. Sounds like they're both alive. And it'll be the earliest date. So in this case, Mary faces a real significant hurdle. The limitation date for her to make a claim for division of property expired in March 2012, 4 years ago. Now, the Family Law Act is the only act that I'm aware of that actually says that a person can go to court on a motion and ask a judge to exercise their discretion to extend the limitation date beyond the 6-year period. And it's a long test of what you have to do. One of them is you want to show that you were in negotiations. You have to deal with prejudice to your husband. There's a whole long list of what you need to do. But it's obvious to me why your husband didn't want to go to court. He was able to stall this matter, so the limitation period expired. I suspect, Mary, you're not aware of that issue. To deal with this, if you still want to pursue it, I think time for negotiation has far since passed, and you should be doing one of 2 things. The first option is you say to your husband, I'm prepared to continue negotiating, but you need to sign something called a tolling agreement. It's a very rare document that gets signed in family law. I've only done it a small handful of times. But what a tolling agreement is it allows the party on consent to extend the limitation date, subject to typically one party giving the other party a certain period of time of notice to say, I'm going to enforce the limitation date if you don't commence a court action. And if your spouse refuses to sign the tolling agreement, then you have no choice. Bring your court application for equalization in that family property, and you're going to have to bring your motion to extend the limitation date. One of the issues is moving as fast as you can. You've got to do it now, because 4 years is already a long period of time. So Mary, I have to strongly urge you not to sit on this, because if you do, I think you're going to have some significant issues, and your case is only going to become harder. But I'm going to continue on to read the rest of your question and deal with the rest of your questions on the merits. You continue to say, at the time he left, we had no debt. We have joint ownership of a house that is mortgage-free. My husband is a retired high school teacher. He has been retired approximately 5 years when he left. He has been collecting a defined benefit pension indexed to inflation. We have the actuarial dollar value of this as it has been evaluated by the Ontario Teachers Plan. He has also been drawing on a small RSP. He started collecting his pension plan early. He was born in 1947. I recently retired from nursing April 2016 at the age of 66. When my husband left, I was working part-time and did not have a pension. Since 2007, I have been working full-time, so I have a very small pension from the Hospital of Ontario Pension Plan. I have been paying into an RSP since 1980 as well as a TFSA. I have just recently applied for old age and CPP. My husband has been renting accommodation since he left. I have stayed in the matrimonial home. My husband has not contributed financially in any way to the upkeep or cost of the house. I have paid for everything. On his own volition, he has done the occasional chores such as cutting the grass, but other than that, he's not done much else. At the time he left, I paid to have the house assessed, so I have a dollar value for 2006. These are my questions. 1. For settlement purposes, is the value of my RSP taken from 2006 or the current value? It's 2006. If it's an asset that is solely in your name, you look at the value in 2006. And for something like an RSP, just like we were talking about pensions, you need to look at the notional tax discount, because that's part of the mix. Is the value of my RSP assessed at the gross value or net value? That's what we just discussed. And it typically is it depends, it's at different rates. A lot of rule of thumbs will be 20 to 25%, but if you want the exact numbers, like I said before, you have to go to an accountant or an actuary. Now here's the second question. Is the value of the house taken from the time he left in 2006 or the current value? Now, remember what I just said, if it's a sole asset, it goes by date of separation. This is a joint asset. You both own it. That means you take the current value of it, and I'm sure you feel very upset because you've made all the payments. Your former spouse would say, well, I had my equity tied up in that house and you had the benefit of living there, the use of my equity, and I couldn't go use my equity to buy something else and enjoy the appreciated value. So the challenge you're going to deal with now is he's going to want his half of the increased value of the home over the last 10 years. And this is a perfectly good example of when people decide not to do anything and you don't want to go to court, it actually can end up costing you a lot more money because you didn't do anything about it. And now it says here, part of the question is, if it is the current value, do I need to get it appraised again, or would the city municipal assessment be enough? Well, it depends. If you're going to sell the home and share in the proceeds, you don't need to get it valued because you're dealing with whatever the value is on the sale. If you're planning on buying them out, you can either try to agree, and if you agree, great, so you may want to rely on the assessed value. But I know I tell my clients not to rely on the assessed value because I haven't ever seen them right. Usually they're significantly understated. And if they are understated, you then have to agree on a process with your former spouse of how you want to get it valued. The two of you may have a real estate agent that you both respect and trust, and you can say to that agent, how much is it worth? And if you both are accepting of it, great. But if it's not going to be one of those and you're insisting on an appraised value, then you get an appraisal and you'll pay $500-600 for the appraisal. That's just the way it is. What you need to also understand is if he's jointly on title, the Partition Act says he can go to court and he will be able to force the sale of your home. And there won't be much you can do about it. So you need to be aware of that as part of the negotiation. Next part of this question is my husband wants to charge me rent from April 2006 until now. That's something called occupation rent. In some cases you can claim it. There's tests to it. But I can think of one court case I was on recently where the judge said, well, I've read the case as an occupation rent, and in my 30 plus years of experience, I've never seen a successful argument made for occupation rent. It's a hard thing for him to get the occupation rent was because A, he left voluntarily, which is only one small piece of the puzzle, but he's also going to be sharing in the appreciated value of the home, and you paid bills on the home. So there's offsetting the issues that are at play during the period of time. So typically the courts don't give occupation rent, and quite frankly there's been a large delay in him breaking his claim for occupation rent, which is also one of the issues we look at. Now you say here, if he can charge occupation rent, what can I deduct as I have to pay? The driveway cleared in the winter, pool maintained in the summer on top of the usual expenses. Well, that's why usually we don't even get into doing those debits and credits, because it's worth a lot more than the time spent is worth more than what the dispute's over. The next question is there a statute of limitation on separation divorce applications? Do you have a settlement in place before you can file for divorce? Well, I've already talked about the statute of limitations because, as I said, that jumps off the page for me. You do not need to have a separation agreement before you have a divorce. In this case, in order to get a divorce, you have to be living separate and apart for a year. These people have done that. That's easy. The second thing is you need to have reasonable arrangements for child support in place. That's easy. There are no children here. So this case is ready for a divorce, but I think you need to deal with it right away. This person asks those questions. I hope that was helpful, and I hope that gives Mary the opportunity to understand a little bit more about her situation. But Mary, you really need to deal with this ASAP. 10 years is way too long, and now, unfortunately, you're putting yourself in a difficult position because of that delay. The next question I have is from Lily. And she says, I'm currently discussing the prenuptial agreement with my boyfriend, whom I will marry in 6 months. In recognition of the hardship I'll go through pregnancy or in vitro fertilization procedures and giving up personal career goals, we agreed on the following 3 versions of spousal support. I'm going to read this slowly because Lily's questions are really detailed and complex. 1, if I was not pregnant or have not started the in vitro fertilization procedures, there will be no spousal support. If the above already happened and married less than 2 years, then he pays the sum of $2,500 per month for a period of 24 months. Now, I'm not sure what she means by already happened, if she means the in vitro happened. If married for 2 to 4 years, he pays me 20% of gross income for 5 to 7 years, pays me 30% of gross income for 7 to 10, and he pays me 40% of gross income for over 10 years, till he reaches 65, or he leaves all the common property to me minus $100,000. He's 38 years old now. The next option is if I was not pregnant or I have not started the in vitro procedures, there'll be no spousal support. If we separate after 2 years, 2,500, or the spousal support advisory guidelines, whichever is larger. Or if I was not pregnant and not started the in vitro, there'd be no spousal support. 2, if the above already happened, you'll pay me lump sum by giving up partial of the common property, say about $1 million worth, which was equal share. If you separate, then you would give me 20% of his share to the common properties for 2 to 4 years, 30% for 4 to 7 years, 40% for 7 to 10 years, and if over 10 years, it'll only take $100,000. He's 38, I'm 33. He earns $100,000 per year, and I earn 50. We both have property worth $500,000 under our own name, which is not to be shared. Please advise what option I should take towards my best interest. Which option would be most enforceable? This is a really complex question, and part of the problem is you're guessing what the future is going to have. Will there be in vitro? Won't there be in vitro? Will you have kids? Won't there be kids? Will you be working? Won't you be working? What will his income be? What will your income be? So there's a lot of things going on here, and as an example, I see you talking about the spouse support advisory guidelines here. Well, I'm trying to understand what the purpose of this contract is, because that's a big and important part of doing a cohabitation agreement. What are you trying to achieve? If you're taking time off work and you're going to be raising the child, then from the sounds of it, I'm not sure why you even want a contract for what you're trying to achieve, because you'll get your child support if the child's living with you, and spousal support in accordance with the guidelines. And if you are going to get married, you're going to have an entitlement to an equalization of net family property. It almost sounds as if you're trying to gain most of the property, and I know from reading what you're trying to do here, I'm somewhat confused. I would expect some of our listeners are probably somewhat confused. And it says to me that if this went in front of a judge may have difficult time following what the logic is. Judges like to understand what was the logic of this deal. Now I'm going to start with what's the right process. If you want to do a marriage contract or cohabitation agreement, both of you need to have independent legal advice. There needs to be full, frank financial disclosure. But what's the logic of this deal? What are you trying to achieve? If you're trying to say, I'm going to be giving up my career because I'm supporting him by taking care of our child or children, well then the family law is going to help you, or I should say the Divorce Act, the family law between support and property should go along, and child support and spouse support will go a long way to assisting you. And trying to come up with complex calculations based on percentages, I'm not sure, quite frankly, they make any sense, and I don't get it. I think you're going to a lot of work for something that isn't necessarily going to achieve anything for you. I would suggest you think long and hard about what the objective is and try to make it something simpler. Because the other problem with what you've done here is also from a drafting standpoint. Clients will frequently say to me, Andrew, what does it cost to draft, say, a separation agreement? Well, I can tell you, to go put together the first draft of a separation agreement that is a cookie cutter agreement does not take that long. But it's the more unique paragraphs that can take a long time to draft. And you may think, well, this is really simple because it's in your head and you get it. But it will take somebody a long time to draft clauses with sufficient particularity to ensure that if there's a dispute about it, the judge will get it. And it will take, you will also, after drafting it, want to do examples to show a judge, in case the drafter did it wrong or there's some ambiguity, what it looks like in a real life situation. And I can tell you, if I was having to draft these clauses, not only would I do that, I would be concerned that I got it right, and I would go to another lawyer in my office and I would say to that lawyer, here are these clauses, tell me what it means, tell me how you would attack it, where's the ambiguity, and probably go through that a couple of times. That's not cheap. You're going to spend a lot of money, and I'm not sure what you're necessarily going to get out of this, Lily. So I would encourage you to really think what the objective of this particular agreement is. Now, I'm going to go to some more questions now. And this one is actually a well-timed question because right now we're about to head into summer vacation for kids. And here's a question: can I take my son on a trip with me? And this is a common problem we deal with. It's people want to take their children on vacations, and will their former spouse agree? And in this situation, it says, I got separated 2 years ago, and my wife and I are still arguing over furniture and a boat we owned. So nothing is final. I want to take my son out to Vancouver to meet his grandparents this summer, and I need to know if this is possible before I call my lawyer to organize whatever documents we'll need and start the bills running up again. Are things different if we decide to go south from Vancouver to Walt Disney World? What are the rules? Well, I'm going to start with, number one, in most separation agreements, both parents will get vacation time during the summer with the kids. And courts encourage parents during summer vacation to be able to take the children on trips because it's rewarding. It's in their best interest. They're good experiences, they're good learning experiences for the children. So the courts want this to happen. In some cases, we have an obstinate parent who doesn't want the child to have a good time with the other parent, so they try to avoid signing it. So how do you go about making this happen? Step one, easy. Send an email or a phone call to your former spouse and say, I want to take them on a vacation. Are you good with that? And they're going to say yes or no. If they say no, you got to find out the reason no. If I say somewhere like Walt Disney World, it's going to be really hard for them to object, providing you have that vacation time. If you don't have that vacation time in an agreement, then it's a matter of negotiating when is the right time, because you may both want that same time off, and you got to work through that problem. But if you went to court, if a client pays me to go to court because they want to book a trip to take the child to Disney World during the summer, you're going to win. You're going to win basically every time, unless there's a really great reason why the child shouldn't go. What do you need in order to make that trip? It is always a good idea to go get a proper travel consent signed by your former spouse and have them get it notarized. You should always bring it with you when you're traveling with your child and have their passport. I know, as a divorced parent, I always have the travel consent with me. And it's interesting because most of the time you don't even get asked. I think I've only been asked twice now to show the travel consent. So most of the time you don't need it, but it's a mistake to assume you don't need it, because if you don't have it, you may find out that you won't be on your flight. So get it. If your former spouse refuses to provide it, then you have to choose whether you want to pay a lawyer, do it yourself, go to court, and get a court order that dispenses with their consent. Now, you might think, well, why should my former spouse consent to it? Well, if you're forced to take your former spouse to court to argue about something as straightforward as taking your kids to Disney World during the summer, you're going to win. The other side's going to pay your costs. And what they will find is you may ask the court to dispense with their consent for trips on a permanent basis, and you may actually get it. And it creates very negative optics for them every time when they go to court after that. Now, in this situation, that's Walt Disney World. What about Vancouver? Well, Vancouver's in Canada. If you stay in Canada, you don't need a travel consent. However, if you have a schedule and you need to clear that it's either A, your vacation time, or if you don't have vacation time, that the other side agrees to it, because if there's court-ordered parenting time that you're removing from them, you can't just do it without their consent. It doesn't mean you need a travel consent to show to fly, but what it does mean you need is you need to have a record of it, so they can't subsequently say you did something to interfere with their parenting time in later disputes. In both of these situations, the court's going to encourage the visits as long as it's not something ridiculous. You can't say, I'm taking the kids for July and August to Vancouver to be with the grandparents, because then when's the vacation time for the other parent? But I think that's a really great question, and the timing of it is terrific. And I should add, be good. When you're thinking about these summer vacations, think of your kids. Do the kids want to go see the grandparents in Vancouver? I think they do. Do the kids want to go to Disney World? We all know they do. So when you think you're going to say no, you're punishing your kids. And if your kids, which they shouldn't find out, but do find out that you said no, there's going to be consequences to that. There's going to be real consequences, because kids are going to be angry. So be mindful of that. Be good to your kids. And remember, put your kids ahead of your dislike for your former spouse. some people will ask me, what are the types of trips that people say no to? Well, the easiest one. If your former spouse says they want to take their children to let's say Damascus, where there's a civil war going on, well, you have a good reason to say no. You're scared for safety. So a good place to look is you go look at the Government Canada website regarding travel advisories. Is there a travel advisory where your former spouse is going? That's a good reason to say no. If you're worried that your former spouse may abduct your child, that's a good reason to say no. But the case law says you can't just say, oh, they're going to a country that I'm worried they're not going to come back from. That's not enough. There's a Hague Treaty that deals with the automatic return of children, and if that country isn't a part of the Hague, that's one issue. But do they have a job here? Is it a good job? Do they own real estate? Where are their family members? If those other issues aren't prevalent, then they're going to get to go there and see the family members. So you need more than just saying, I don't like the country. Now, I do see that we have a question on Facebook Live from Kimberly, and she asks, do you think the Facebook divorce rate is high because you hide a lot of what you're doing so easily? I do know that Facebook is causing more and more divorces. Would I say that it's high because you can hide what you're doing on Facebook? I'm not sure how much you can necessarily hide. You have to think about it from your spouse's perspective. If you're hiding your Facebook page from your spouse, they're going to wonder what's going on. And part of it depends on how many friends you have. If you have 3,000 friends, odds are one of them is going to be somebody who's going to report back to your spouse on what you're doing. And I find it amazing sometimes what people are prepared to say and do on Facebook and just assume their spouses aren't watching. They may very well be watching. So Facebook can cause problems, but it's a question of, is the other spouse watching? Really, in a way, it's no different than day-to-day life or people watching. If you block your spouse from seeing anything on your Facebook page, most spouses are going to ask why. At least that's my common sense viewpoint of that question. But I won't say that Facebook doesn't cause a breakdown of marriages, because you can text message with somebody on Facebook, but guess what? You can text message somebody on your cell phone the same way that your spouse can't see, because that's password protected. It may just be Facebook is another way of getting together with people from your past that then takes you down a certain pathway. Or some people get so obsessed with Facebook that they spend inordinate amount of time and they forget that they actually have a partner. And thank you for that question, Kimberly, since you're our first person asking a question on Facebook Live. I'm going to move over to our next question, part of our questions that come in before the show. And this is it. My office has summer hours and I want to adjust pick-up and drop-off times. Over the summer, I get 4 Fridays off. Normally, I pick up my kids, a boy who's 6 and a girl who is 7, from their after-school care program on Friday afternoons. Except for one Friday when I'm going fishing for the weekend, I want to take the kids on Thursday instead. I'm not sure if my wife will agree. One of the reasons we're separated is that sometimes she's just plain mean for no good reason. I hear a lot of that. Do I need special papers signed by my wife? Do I need a judge to okay this? Let's start. I'm going to say to you that if you've settled your case and you have an agreement that sets out your schedule, you're not going back and paying the money that it costs to get in front of a judge so you can pick up your kids early for a Thursday fishing. This gets back to my earlier statement. If one parent isn't going to do and agree to these kind of trips to the other parent, most likely after hearing no, you're going to do the same back. So there's a mutual problem that's created. I don't think most daycare providers are really going to object if dad picks up the child early on a Friday, or even first thing Friday morning during the summer. Speak to the daycare providers and find out what they say. You do have to ask your ex if you want to take the kids on Thursday. If she says no, well, quite frankly, you're stuck with that, because I don't think anybody wants to pay a lawyer to deal with that problem. That's why I would say you don't want to go in front of a judge. If the daycare says, well, we need some permission from mom so you can pick up the child Friday morning from daycare, well, then see if you can get mom to send an email to the daycare. There isn't a special paper. There's no magic for that, but it's something, it makes sense. I know my ex and I have coordinated that for early pickups and things like that. Most people do. sometimes you're involved in high conflict cases and you just can't do it. And regrettably, that's part of being in a high conflict case. You'll be stuck with it, and you're not going to want to pay the bill for that. I mean, it's just, unfortunately, it's really common sense. Okay, and I'm just checking Facebook Live to see if there's any other questions. I see Hannah asked, what's been my most challenging case? Well, in 22 years, there's been a lot of cases. I've dealt with child abduction cases. I've dealt with people hiding money offshore and trying to make sure their members, their former spouses never get to see it. People who do horrible things to their kids. So there's a lot of things in family law that can be very emotional and draining. And at the same time, as saying that, it also can be the most rewarding area of law because you actually really get to help people and impact their family relationship. And sometimes I'll be out just at the local mall and someone will come over to me, and I was their lawyer 10 years ago, and they introduced me to their kids that are grown up, and they see such pride, and they tell me how I was able to help them to ensure they have this great relationship with their child. And it's a great feeling to be able to know that you were able to touch people like that and really have an impact on them from your work. Whoops, I'm just trying to check some more from Facebook Live. I'm not seeing any other questions that are for me on Facebook Live. So the next pre-asked question, my apology for the delay. I know the last thing you're supposed to do on TV is have a quiet time, and I did that, so my apologies. But I'm going to go back to the questions that came in before the show. Who pays for camp? Another great question at this time of year, even though a lot of people have probably already paid for it. My son turned 8 in March. His 2 best friends are going to camp. He wants to go with them. My ex-husband loved camp, and so did I, so we've already registered our son, but I don't know who pays. My husband gives me several $1,000s a month, and I have a decent job. My husband makes a good living even after he makes the payments to me and our son. We've agreed to pay for camp by following whatever Ontario divorce law says about expenses like this, but we don't know the rules. It's a great question. Here's one of the problems I face. Clients ask me questions, and there's always some gray area. So first of all, if you already have a separation agreement, you should turn to the separation agreement because that should set out some guidance for you. But if you don't have a separation agreement, then how do you deal with this? Well, there's the child support guidelines. And the child support guidelines are basically the same for Ontario and for across Canada. The child support guidelines will say that you look at the father's income. He's the payor, and it will give a table amount of child support that he has to pay every month based on his income. And I'm assuming that's the one that you say is several $1,000s. And it's important that you mention that it's several $1,000s. Because then there's also something called Section 7 expenses. Why Section 7 expenses? Because it's pursuant to Section 7 of the guidelines. And that says if there are extraordinary expenses that parties can have, or the husband, both sides can have to contribute to these expenses over and above the table child support, and they have to be reasonable and necessary. Do I think summer camp is reasonable and necessary? Yes, I do. How do you determine how much each side pays? Well, you take the father's income, you take your income, you add it up, and then you take each side's income and divide it by the total income to get a percentage that each of you make, and then you would pay that based on your respective percentages of the total pot. However, if he pays you any spousal support, this only applies to spousal support, you would deduct the spousal support from the payor's income and add it to the recipient's income in order to get to that pro rata sharing. So that's, I would argue, the starting point. Because then the payor could suggest that depending on the amount of these expenses and how much support he's paying, that his table support includes the cost of summer camp. Part of that would be what's the cost of summer camp, because you could be sending your child to a city day camp that could be a couple $100 a week, or you could be sending them to a private camp that could be overnight and be $1,500 to $2,000 a week. So there's a whole different range. I certainly think the less expensive camps, if he's paying several $1,000s a year, may very well not be a Section 7 expense, but a more expensive camp certainly would be. That's the gray area, and there's lots of gray in family law. I would say in most situations, summer camp is a Section 7 expense that should be paid on a pro rata basis between the two of you, and that would be the overwhelming number of cases. Now, I see another question has come in on Facebook Live. Kimberly says, in Canada, if you want to take your children to the US or out of the country, but your spouse doesn't want you to, I apologize, I just got an email at the same time that went over the question, so I'm going to start over. In Canada, if you want to take your children to the US or out of country, but your spouse doesn't want you to, if they are the main custodial, can they get an anti-removal order to stop you from taking the child? Well, the answer to that is really simple. And this goes back to what I was saying before. It's going to be very, very difficult for them to stop you from being able to take the child away on a vacation if it's a reasonable vacation. So if you want to take your child to Disney World or somewhere else in Florida, New York City, Chicago, LA, anything like that, just because they're the custodial parent doesn't mean you shouldn't be able to do it. And if they're saying no, they're probably being unreasonable unless there's a problem with you. If you're an alcoholic, you're a drug addict, there's a problem with you caring for the children, something like that would be a legitimate reason. But otherwise, you're going to be able to take the child. That's just the reality of the situation. And that's the way it works. I see that we can move on to question number 4, the next question that came in before the show, which is, do I need character witnesses? This is a fairly common situation that I get into. People will come into my office and say, I'm a great parent, my former spouse is a horrible parent, and they have a whole bunch of people that they line up as witnesses. And this person relates it to a real life celebrity situation. They say, I've been reading about Johnny Depp and his wife Amber and the terrible things she has been saying about him. And Johnny's first wife and his children have countered saying, that's what Amber says is not true. My wife and I do not get along anymore, and we've talked about separating. One of our problems, at least from my side, is that I don't trust her, and I'm worried she's going to lie about me to friends and business colleagues and in whatever court papers we need to file. Should I line up character witnesses before we file for divorce papers? I can tell you, I've done this before, and when I've done this for clients, usually the court's pretty dismissive because most of the character witnesses that people line up are the family and close friends. And they understand your mother, your father, your brother, your sister are usually going to be giving positive statements about you. So if you're going to do this, it can't just be the generic, hey, he's a really good guy and he's a really good parent. It should be something that has a lot more to it. So if you're able to go get your child's hockey coach who says, you know, you've taken the child to every hockey game, every practice, the other parent's never there, you've done all these wonderful things, that's at least somebody that's independent. They don't have an agenda to support you. That would carry more weight. Is it a good thing? I'm not sure that much is going to turn on it, but it's certainly not a bad thing. So if you can get them, yes, but don't think that's the be-all and end-all. Judges are familiar that family law, it's full of he said, she said. And regrettably, there's too many cases that are full of character assassinations. And these type of character assassination cases happen far too often. And it can backfire, because if you don't have any real supporting evidence of the tactics that you're talking about from the other side, well, that may blow up in your face because the court isn't necessarily going to be impressed with you for doing that. Now, I just got another text message that came in, and it says, I'm getting married in the fall and I have a small business. Should I have a valuation done on it and have my fiance to sign off of it? I think that depends on what the kind of business is and what you want to do with it. You say it's a small business. Well, a small business could be a business that could be a plumber, and he has one van on the road, and really all he has is a job. Do I think that type of business needs to be valued? Not so much, because what you're going to do is you're going to look at the financial statement of the company, keep that financial statement, make sure you show it to your spouse, and that way they know what the value of your business is. If you have a much larger business, should you have it valued and you're getting married? No, if you're not getting a marriage contract. Make sure if you are not getting a marriage contract that you keep the financial statements for, I would say, 3 years prior to the marriage and a couple of years after the marriage. Make sure you keep them. And you don't keep them at home. I've had too many cases where people have kept really important documents that support what they had on their date of marriage in their house. And they come to my office and they say, Andrew, I got all the proof. I had $500,000 in a bank account. It was at the TD. I got the statement at home. Not a problem. They go home. They look for it. They phone me. It was there 2 weeks ago, Andrew, and it's gone now. That $500,000 statement from an equalization standpoint would have saved them $250,000. What a shock, their spouse shredded it. And you got no proof. So what do you do with it? You should always leave it in the in your own safety deposit box. Make sure you have the original in the safety deposit box. You can keep your copies elsewhere. Put the originals in the safety deposit box. And I would even say you can't trust anyone with it. I always remember one client of mine who said she got the important paperwork she needed, she secured it, she gave it to her best friend. The only problem was her best friend was the mistress of her husband, and we couldn't prove anything in her case. It all went out the window. Safety deposit box is the best place. That's what I did for my first marriage, and it certainly helped. If I will take that question and frame it slightly different. If you are getting a marriage contract or cohabitation agreement, well, disclosure is critical. You need to give all the information to your spouse. If you're going to give all the information to your spouse and you have a business that has some goodwill or some real value to it, should you get it valued, then yes, you should. Because that way your spouse has all the information they need in determining whether they should sign that contract or not. Now, here's another text message that just came in. My husband is hitting our kids when he has them. When my kids come home, I ask them, what are the bruises from? They tell me their dad hits them. What can I do to stop my husband from seeing them? Well, you have a legal obligation to report that to the Children's Aid Society. He's hitting them. He shouldn't be hitting them. You should report it to the Children's Aid Society. They will investigate. They will make a determination whether the children are in need of protection from him, and they'll give you some guidance in that area. If you want to stop them from seeing without calling Children's Aid, but keep in mind that it's your legal obligation, and if you don't call them, the judge is going to say in this situation, why didn't you call them? You would have to take them to court. The other thing you can do is you can take the children to the pediatrician and make sure you take pictures of what happened, but you got to be very careful whether you want it. I have to rethink the taking pictures, because the problem when you take pictures is you got to be very careful with what you're doing, because you don't want to make your children feel bad, and you certainly don't want to take inappropriate pictures of children, because that can get you in trouble as well, depending on where the children were hit. But it's a really good question, because it's a problem that sometimes happens. I'm just checking back on Facebook Live now to see if there's any more questions. No more questions, so I'm going to move on to another question that we had before the show. Should I marry again or live common law? I separated from my husband 4 years ago, and we've been divorced for 2.5 years. We have 2 children, a boy who's 12 and a 15-year-old girl in high school. The kids and I live in the original matrimonial home. I have a new boyfriend. Let's call him Bob. And I want him to move in with us. The children know him and like him, but I don't think my ex-husband is going to like the idea of another man living in his house. If Bob moves in, does he owe any kind of rent payment to my ex-husband who's still paying the mortgage? Does it matter to my spousal support and the kids' support payments if Bob lives with me? Does it make any difference if we get married or just live together? Now, these are some interesting questions. If you are receiving spousal support, and I would arguably suggest if your ex-husband is paying the mortgage on your house, that's sort of a form of support. The fact that another man is moving in opens the door for it being a change in circumstance. Now, the new guy doesn't have any obligation to support you until you're living together for 3 years, or if you have a child together and you're living together. However, he may need to contribute to the expenses, and your former spouse may want and probably will ask for a reduction in spousal support, and will ask for Bob's financial information, being his last 3 tax returns, and you'll have to get him that information. Does it matter to my spousal support and the kids' support payments if Bob lives with me? It only matters for your spousal support. It does not matter for the child support. Does it matter if you get married? Yeah, it does matter, because if you're married, Bob immediately has an obligation to support you, and it puts you in a worse position, because then that material change has certainly been triggered for the revisiting of what the appropriate support ought to be. So by Bob moving in, are you causing yourself a problem? Yes. If you get married, are you causing yourself a worse problem? Yes, you are. Okay, next text question. I'm starting a business and my accountant advises me to give 1/2 of the shares to my wife for income splitting. This makes me nervous if we ever get divorced. What should I do? Don't listen to your accountant. From a family law perspective, it's bad advice. Here's why. An accountant will probably say to you, it doesn't matter who owns the business because she's going to get her half for equalization. Well, I ask you this question. If you separated, like I said at the beginning of the show, the equalization of net family property is based on data separation values if it's a sole asset. Joint, if it's, or you deal with it on the date of the deal if it's a joint asset. Do you really want to be going to work every day, running a business, working hard to increase the value of that business, and then you separate, you continue doing that and grow the business, and your former spouse gets to participate? Do you want your former spouse being able to say, hiya partner, and show up at the office? Do you want her questioning where you're paying business expenses, saying you shouldn't have paid them there? There's a whole host of problems that can happen by making your former spouse a partner. I strongly recommend against it. I don't think it's worth doing. The next text question we're getting is, if there's a possibility of the respondent going to jail, can we ask for sole custody in a case conference brief? Well, I would suggest ask for it. Can't hurt. You're probably not going to get it at a case conference. Depending on how long your former spouse is going to jail, I certainly think it increases your chances. If he's going to be in jail for a week, it's a lot less important than if he's going to be in jail for 2 years, because you have to be able to get his opinion and be able to do it on a timely basis, and you won't be able to. So I certainly think it's relevant. The next text question that I have, I got a follow-up one, says, also, do we include evidence as in letters from healthcare professional about the children's health? Well, if you're going to a case conference, it depends what information you're providing about the children's health. Are the children having some problems you want the judge to be aware of? And how is your spouse dealing with those problems? If he's dealing with them inappropriately, yes. If it's something that requires regular decisions to be made and your former spouse is in jail for a prolonged period of time, yeah, you put that in. And you explain to the judge why it's relevant to custody issues. I know we're getting close to the end of the show, so I'm going to deal with another text question that came in. My son and daughter will not let me see my grandchildren. I'd like to see them. Do I have any rights as a grandparent? That's a pretty complex question. You do have some rights as a grandparent. That's clear. But it depends how. So if you're a grandparent that had no relationship with the children, never did have a relationship with the children, for the most part, a court will respect the wishes of the parents because they know the parents get to make the decisions for the children. They respect that the parents have autonomy in that regard. But if a grandparent has had a consistent relationship and then a parent says, no, you're not going to see them anymore, the court may not respect those wishes. The strongest situation for grandparent access is when their child has passed away and the former daughter-in-law or former son-in-law is interfering with the relationship. Because now it's no longer your own child saying no, it's simply the in-law saying no, and a court's going to be significantly more sympathetic regarding that. There are some more text messages. I'm going to deal with one last one before we end the show for this evening. And the question is the court required to pay for a court-ordered psychological evaluation? The court doesn't pay for any experts. What can happen is if there are children involved, a party can go to court and ask for the appointment of the Office of the Children's Lawyer to assist in advancing the position of the children. It's a way for the court to get to the bottom of what's in the best interest of the children. The judge has to make that order. The Office of the Children's Lawyer has to say whether they will accept it or reject it. And they don't always accept them. The judge doesn't always make the order. And if they do appoint the Office of the Children's Lawyer, you'll get a social worker, a lawyer, or both. I know we're just coming to the end, so I'm going to say that when we started tonight, I said an hour goes by quickly, and it does. And in the last few minutes, we've been inundated with a number of texts, which is great. We had a lot of questions before the show. On our next one, I hope that people are texting earlier in the show, so I have more time to get to all the texts. I want to thank everyone. I want to thank everyone who sent in the messages both before and during the show. I want to thank all the people that have been commenting on Facebook Live and watching Facebook Live. Judging by the numbers, it looks like tonight's show has been a success. We will be back on Wednesday, July the 20th, 2016 with another episode of Ask Andrew. In the meantime, remember there's family law information in easy to understand language on separation.ca and on familylawhelp.ca. Thanks for watching. Please come back in a month, and good night.